I'm going to tell you a little bit about how our debt settlement program works. Before I do that, I think it's important to explain the difference between debt settlement and debt consolidation. Debt settlement is actually quite different from debt consolidation. Debt consolidation is when you pay back the full amount of the debt over a really long period of time, and you're really paying the creditors like little tidbits every month and eventually paying off the full amount of the debt. With a debt settlement, that is the process where we negotiate with creditors to reduce the overall principal amount of the debt for a fraction of what you actually owe. Before we do anything, the first thing that we need to do is have a really good understanding of the client's financial situation and their unique set of circumstances so we can figure out what is the best option for that particular client. The first step is the gathering of information. We have highly talented and skilled debt analysts that will help the client gather information about their income, their expenses, their assets, their liabilities. We're going to find out about their financial hardship and what put them in debt to begin with. After we have a full understanding of that, we will next go through their creditors in really great detail. So who do they owe money to? What kind of debt is it? What is the status of the particular account? Is it delinquent? Is it collections? Are they about to be hit with a lawsuit? So we really try to get a full understanding of that before we do anything else. Once we know exactly who their creditors are, how much money they owe, whether it's the kind of debt we can even enroll in our program, because generally speaking, we'll only enroll unsecured debt. And what that means is it is debt that is not secured by collateral, such as a house or a car. So credit card debt would qualify, medical debt, personal loans that are not secured by collateral would also qualify. Once we have a list of their creditors and the total debt owed, we basically will rate the client's file as a whole. What that means is we will assign a settlement percentage to the client's file as a whole, which is essentially a very reasonable estimate of what we believe we should be able to settle all of the accounts for based on our past experience dealing with these same creditors. We will customize a program for that client, which is essentially based on their ability to pay, and the programs will range from as little as 6 months to as much as 4 years. Once the client picks a program that they're comfortable with, the next step in the process is them meeting or speaking with our legal director. Our legal director will go over everything with the client in greater detail. He will show the client everything in writing. He will go over our retainer agreement in very great detail, particularly pointing out provisions in the agreement that completely protects the client. At the same time that the client enters into a retainer agreement with our office, they simultaneously enter into an agreement with a third-party processor. Now, this third-party processor is completely separate and independent from our law firm, and what they do is set up and maintain a special purpose account for the client. The special purpose account is an account that is used to accumulate funds for the settlement process. Now, the special purpose account is special because it has many added protections that protect the client, unlike a general attorney-client trust account, which every attorney is obligated to have by law. So, for example, a general attorney-client trust account is an account where everybody's money would go into one big general account. The special purpose account is special because it's separate. Only the client's money goes into that one account. No other client's funds are commingled together with that client's money. And that's nice because the client will have access to their account anytime they want to. They'll actually get a login ID and a password that is personal to them, and they can go online anytime they want and see what's going on in their account. The other nice thing about the special purpose account is that the client has complete control over the account. The client decides what happens with the money. No money goes out of that account without the client's express consent and approval. So every time we reach a really good settlement with the creditor and we present that to the client, they have to accept it. And only when the client accepts the offer will the third-party processor be instructed that it's okay to pay that money to the creditor. So the client has complete protection in that regard. The special purpose account is actually also really easy to use. The client essentially doesn't have to do anything. All they need to do is make sure that the funds are available for the third-party processor to debit. The client will choose the date that they feel comfortable having the money debited. If the client wants, they can even choose bi-weekly payments. It'll get debited twice a month instead of once a month. The money will automatically get debited on that date the client chooses, and it will automatically go into their special purpose account. Again, that special purpose account is theirs. They have complete control over it. And if for whatever reason the client is unhappy, there's a 100% money back guarantee. That's their money, so they have a right to take it whenever they want to. Now, it's also important to understand that the money that goes into the special purpose account is, generally speaking, hundreds of dollars less than what they were struggling to make on minimum credit card payments alone. So while the client is in the program, they're actually comfortable because they're paying less than they were struggling to pay before. After the client finishes their meeting or speaking with the legal director, by that point they should be really comfortable. They should really have a good understanding of how the program works, and they should feel like they're safe and in really good hands. The final step before the client officially gets enrolled into the program is called the compliance portion. And that is the part where I, as the lead attorney or one of our local attorneys in the particular jurisdiction the client lives in, will get on the phone with the client and have a compliance call, which essentially goes over everything that the program is about. As the attorneys, we are the eyes and ears, the last set of eyes and ears that reviews the client's file as a whole. So we will go through the program terms, make sure the debit date is accurate, make sure all the creditors are there, make sure the client's budget analysis makes sense, that they feel comfortable making the program payments, and then also fully disclosing all aspects of the program to the clients. So all the pluses, all the minuses, everything is completely honestly disclosed, so the client knows exactly what they're getting into. And really, I like to think of it as a question and answering session. The client is encouraged to ask as many questions as they have, and we will try our best to as truthfully and honestly answer. So by the time the client is done with that part, they definitely feel like they're in good hands and they're ready to move forward. Law firms can generally prevent creditors from harassing calls and demands that they place on clients. Generally speaking, when creditors know that our clients are being represented by a law firm, they're much more careful, they're much more cautious, they're less likely going to be harassing clients, and they will generally deal directly with us, giving our clients some breathing space, which is really important to them.